Kizza Besigye, a longtime opposition figure of President Yoweri Museveni, skipped the opening of his treason trial, saying that the judge is biased. Besigye and his aide, Obed Lutale, refused to attend after the judge denied bail and will not step down. Their lawyers say that makes a fair trial impossible, especially given the gravity of the charges, which can carry the death penalty. Now, the case was moved to a civilian court after Uganda's top court said military trials for civilians are not allowed, but the boycott has now stalled proceedings and pushed the plea hearing back. Rights groups and many observers see the row as another sign of worrying pressure on Uganda's justice system, an especially sensitive issue as the country heads towards the 2026 elections. Well, to discuss more on this, I'm joined by Samuel Wanda. He's the managing partner, Matsiko, Wanda and Arinda Advocates. Thank you so much for joining us on the show, Samuel.
Thank you so much for hosting me.
It's a pleasure.
Good evening to you and to all our viewers.
Good evening, Samuel. So, Samuel, tell us, from your perspective, how strong is the claim of Judge Emmanuel Baguma's bias in legal terms?
Thank you so much. Even if it's the slightest of bias, a judicial officer should not stand in the way of justice and for a fair trial. However, for Justice Emmanuel Baguma, it's more than the slightest of bias because of how he has conducted himself in this matter. It dates back from around April when he was transferred to this particular division from another division. And at times we think the intention to transfer him here was particularly to handle this matter. We filed two separate applications. The first application was a normal bail application, and the second application was a mandatory bail application after our clients reached the mandatory period of 6 months in custody without trial, all their files being committed to the High Court. Justice Baguma sat onto both files. He never fixed them, but he had allocated them to himself. We had another application for revision on some of the orders that were issued by the Chief Magistrate's Court, where they wanted to handle a particular application in camera. When the revision application was fixed, Justice Baguma took the file away from the presiding judge and he wanted to handle it himself on that day, and later changed and said he cannot handle it because he hadn't fixed it for that day. Thereafter, he fixed both applications in the next month, which was early last month. We appeared before him, made our arguments. The state made arguments. The state did not deny that Dr. Kizza Besigye and Judge Obed Lutale had prior been in custody under the military court-martial. However, the shocking bit in his ruling, he insisted that for him he is not aware, and neither have we brought evidence, despite affidavit evidence, both from the applicants and then from the state, indicating that indeed this had been in military custody from November last year up to the date when he had the application early last month. And therefore, he dismissed the application for mandatory bail based on that ground, which we believe was a biased ground, and he ignored crucial evidence that was on file.
All right, Samuel. Samuel,
yes.
Just before you go ahead, now, since Besigye, and his aide refused to attend the hearing, does a boycott help the defense's credibility, or does it risk, playing into the hands or the state's hands?
One, as lawyers, we act on instructions, and our client has categorically said he will not appear before the particular judicial officer. And if the judicial officer thinks he can try him in absentia, then that leaves to his understanding. However, and this is the entire reasons for the boycott, in any situation where an accused person has indicated that you're biased and they have prayed for your recusal, it's just legal, it's just logical that you excuse yourself from a particular trial. Unfortunately, our rules on recusal do not allowed to appeal on such a ruling, and it only allows you to have the ground of bias as an appeal ground after the trial has been concluded and if you're convicted. Now, for us, we don't want to play to the gallery and wait until the trial is concluded to ensure that Justice Baguma leaves the trial. Why do we say that? We are certain and sure of their intentions. All the way we started from the General Court Martial, the intentions were very clear. Have a summary trial, convict him. Not sure if they will execute the sentence or not, but that's what we know. And therefore, even if you're tried here and you're convicted, it becomes hard, even on appeal. We all know the court system in Africa. You will appeal and your appeal will take 10 years before being heard. So for how long shall we be in the ping pong? And that's what we are saying, that we shall not appear before him.
All right, now away from Africa, let's focus on Uganda now, because his lawyers argue that the judge is incapable of delivering justice with fairness and impartiality because the judge refused to grant bail and rejected requests to step aside. But does that reflect a broader perception of Uganda's judiciary? How unusual is it in Ugandan courts, for a judge to deny both bail and recusal in such a high-profile case?
Ordinarily, and particularly in Uganda, whenever judges have been requested to recuse themselves from particular matters, they have heeded to. And this comes from a principle of justice should not only be done, but it should be seen to be done. And in situations of such matters, where someone has alleged that you're biased and the allegations are not misconceived, the allegations are true, they are logical from the applicant side, indicating that you ignore the basic evidence available to you, both from the applicant and the respondent, who is the state, indicating that the person has been in custody from November 2024 to up to now in August, when you had the bail application. And in your ruling, you say the applicant has not brought any evidence to prove that he was under military detention from that time. And you're only aware from the time he was charged in the normal courts. Now, that's the challenge, and that shows that indeed the judge is biased. So the biasness is not misconceived, it's real, and ordinarily, any judicial officer who is intended to offer a just and equitable remedy would ordinarily stand down, and also in the interest of right to a fair hearing, where no one should be a judge in their own case. Here we believe Justice Baguma is a judge in his own case. He has shown his side of the story. He has shown that he's intended to prosecute these people. When you looked at if you have read the ruling, he further said, this being a matter of public interest, I would ask the registrar of this court to fix it for hearing. Now, even when it was fixed for hearing, which it came up yesterday, the defense has not received any disclosure from the prosecution. Now, and Mr. Baguma was ready to start the hearing. So you can see the nature of biasness with the judge, and we do not expect that the applicants can get a fair trial at all circumstances.
All right, so let's also quickly talk about, Besigye's treason charges, which carry the death penalty in Uganda. Looking at Besigye's long political profile, four-time presidential challenger, and also a familiar face, in Uganda's opposition. How does this, raise the stakes in terms of judicial independence and transparency?
Of course, treason the stakes high. We're just not certain whether the judiciary can stand to the test. You may know that it's not the first time he has been charged with such grave offenses. He has been charged with treason twice. He has been charged with terrorism. He has been charged with rape and several other offenses. The state had never prosecuted any case except the one of rape, which was dismissed at the earliest opportunity by court for them not showing any reason why he should put himself to the defense. Now, with the state, it's expected that with such a trial, with such a grave offense, with such a political figure who has been a figure in the country's politics from the 1980s, the judiciary should act independent, should be seen to be independent, and should be seen to deliver justice. Because the risk we run is that if Dr. Besigye and his aide, Obed Lutale, cannot receive justice, then is there any other ordinary Ugandan that can receive justice? And those are the stakes for the judiciary to answer. However, the judiciary has shown that it's not ready to adhere to any of the basic principal standards of the right to a fair hearing.
All right, now, Samuel, rights group have actually said, that this case is part of a pattern of repression, ahead of the 2026 elections. And analysts have also, long said that Museveni's government uses treason and terrorism charges in order to keep opposition leaders tied up in court. That's to keep them busy, so that the election can actually go on without any form of reproach. But then, would you say that this particular trial is politically motivated as well?
Thank you so much. Yes, we
looking
do
at the
believe,
timing. Looking at the timing, yeah.
Yes, we do believe that this particular trial is politically motivated. It's intended to keep Dr. Kizza Besigye out of the politics of this country. And not only him, several other politicians. And as the state ages in power, it's more it loses control over the electorates, and it's more they try to get more repressive means to deal with the politics of the day. Mr. Museveni and his colleagues have been here for long. They have failed to give the basic necessities to the citizens. So the best they can do is repression. We have several people living at Besigye alone, several people who were arrested in 2020 who belong to the National Unity Platform today. Majority of them are still languishing in prison. Majority of them were charged with offenses related to national security and terrorism. And they have never had their day in court. You can imagine those are 5 years. Dr. Besigye has been in custody. Now it's coming to a full year. His trial has not taken off. They have not disclosed any evidence that they even intend to rely on him. So when rights groups allude to the fact that this is politically motivated, we do not have any doubt in it. It's not the first time it has been done. It was done in 2005. It was done in 2016, immediately after the elections, before the swearing-in of Mr. Museveni. And we've seen it even happen in 2020 to another group of opposition politicians. So we are not shocked by what is happening today. And in the event, it was never politically motivated. In the event, it was never to allow or to restrain the Besigye from participating actively in the politics towards the run of the next year's presidential general elections. Then even the courts should have been at liberty to grant him temporary freedom as the trial commences, because this is not the first time he has been charged with similar offenses, and all the previous courts at least granted him the temporary freedom, and he had the matters dismissed even without him going on his defense.
All right. Well, thank you so much, Samuel Wanda, for joining us and speaking on this. We appreciate you for your time.
You're welcome.
Well, that was Samuel Wanda, Managing Partner, Matiko Wanda and Arinda Advocates. We'll take a break. When we come back, the show continues. Stay with us.